Now I am going to dictate a legal passage based on Kolkata High Court's judgment at the rate of 120 words per minute. Let's start. This appeal arises out of the judgment and order dated 15th March 2023 passed by the learned Additional Sessions Judge Hooghly in Sessions Trial number 47 of 2022, whereby the appellant Mr. Ramesh Chandra Das was convicted under Section 304 Part 2 of the Indian Penal Code and sentenced to rigorous imprisonment for 5 years and to pay a fine of rupees 10,000, in default of which he was to undergo further simple imprisonment for 6 months. The prosecution case in brief is that on 22nd July 2022 at about 7:30 p.m. the appellant had an altercation with the deceased Mr. Subhash Mondal over a boundary dispute in the village of Singur. It is alleged that during the quarrel, the appellant in a fit of rage struck the deceased with a wooden stick on the head, causing grievous injury. The deceased was taken to Singur Rural Hospital and later referred to SSKM Hospital, Kolkata, where he succumbed to his injuries on 24th July 2022. An FIR was lodged by the brother of the deceased Mr. Probir Mondal at Singur Police Station under Section 304 IPC. The appellant was arrested on 25th July 2022 and remained in custody during the trial. The prosecution examined 8 witnesses, including the informant, the doctor who conducted the post-mortem, and the investigating officer. The defense examined none. The learned trial court, upon appreciation of evidence, found that the appellant had no intention to kill the deceased but had acted in a rash and negligent manner, thereby attracting the provisions of Section 304 Part 2 IPC. Learned counsel for the appellant Mr. A.C.K. Ghosh submits that the conviction is erroneous and unsustainable in law. He argues that the incident occurred in the heat of the moment without premeditation and that the appellant had no knowledge that such an act would likely cause death. He further submits that the medical evidence does not conclusively establish that the injury was sufficient in the ordinary course of nature to cause death. Learned counsel for the state M.S.R. Banerjee supports the judgment of the trial court and contends that the appellant's act was reckless and dangerous and that the conviction under Section 304 Part 2 IPC is justified. I have heard the learned counsels at length and perused the records of the case. The postmortem report within bracket Exhibit 5 reveals that the deceased sustained a depressed fracture on the left parietal bone leading to intracranial hemorrhage. The Dr. PW6 opined that the injury was sufficient to cause death in the ordinary course of nature. The testimony of PW2, an eyewitness, corroborates the prosecution's version. He stated that the appellant struck the deceased once with a wooden stick and then fled the scene. His testimony remained unshaken during cross-examination. The defense did not dispute the occurrence of the incident but argued that the act was not intentional. The appellant's statement under Section 313 CRPC admits to the quarrel but denies the assault. The central question for determination is whether the appellant had the knowledge that his act was likely to cause death. Section 304 IPC is divided into 2 parts. Part 1 appeals when the act is done with the intention to cause death or bodily injury likely to cause death. Part 2 applies when the act is done with knowledge that it is likely to cause death but without any intention to cause death or such bodily injury. In the present case, the evidence does not suggest any prior enmity or premeditation. The quarrel was sudden and the act appears to have been committed in the heat of passion. Stop. Thank you.